Thank you, counsel.
Thank you.
Mr. Liu?
Mr. Chief Justice, and may it please the Court. In Tyler, this Court looked to history and tradition to conclude that a taxpayer is entitled to just compensation when his home is sold for more than he owes. The same history establishes what compensation is just. As long as the sale is conducted fairly, just compensation is the surplus proceeds. According to petitioner, compensation should instead reflect a property's fair market value. But as this Court recognized in BFP, foreclosed property is simply worth less. Petitioner's approach would defy that reality and spell the end of tax sales in this country. As for the excessive fines clause, it's simply not implicated here. Any taking that's justly compensated for can't be a fine, can't be punishment, and can't be excessive. I welcome the Court's questions.
Mr. Liu, you seem to put a lot of weight on the fairness of the process. How do we determine that? Do we look at history and tradition? Do we look at, as petitioner argues, at least as a part of this, the end result, whether or not the price is fair market value? What should be our gauge for that?
I do think we look to history and tradition to determine what a fair sale looks like. I think some helpful guideposts are the Cooley Treatise starting at page 334 that goes through the historical practices of jurisdictions at the time. I think the federal government's 1812 statute is also a helpful guidepost. And I think if you look at those guideposts, they're basically three minimum ingredients of a fair sale. One is public notice that contains the time and date of the sale, a description of the property. The second is that there must be a public auction. It can't be a secret sale. It can't be a private sale. And the third ingredient is that the auction must be competitive. There must be an opportunity for bidding and sale to the highest bidder. And of course, you can also look to history and tradition to also figure out what is the amount of the tax debt that can be subtracted from the sale proceeds to yield the surplus proceeds. But do I think the inadequacy of the price bears on that? I'm not going to dispute that a truly grossly inadequate price should cause a court to look more closely at the procedures. But the fact that the price is inadequate is not alone enough to justify setting aside the sale, and it never has been for the centuries that tax sales have been conducted.
Has the taxing authority and power of government superseded that of the constitutional right to private property?
No, I don't. I mean, if I'm hearing the question correctly, no. The government's authority to foreclose on property doesn't supersede any private property rights. I think what the taking clause reflects is a really important guarantee of what happens when the government does take property, and it's the guarantee of just compensation. That's the balance the founders struck.
Are there more protections in mortgage foreclosures, for example, than there are in tax foreclosures?
There may well be. If you to contrast some of the cases my friend cited, he cited Gresham and Ballantyne. I mean, those were not tax sale cases, and they did mention this concept of gross inadequacy of price. If you look at the court's on-point opinion on tax sales, which is Slater versus Maxwell, the court rejects the notion that tax sales could be challenged based on a mere inadequacy of price. So
that's not what I'm not talking about. That it seems as though when we talk about such things as mortgage foreclosures, which we of course know are contractual, but there are all sorts of built-in protections for the homeowner. Are there similar built-in protections for the taxpayer in tax foreclosures?
I think there are, but I don't think they're constitutionalized by the takings clause. I think federal and state statutes have long proven perfectly capable of protecting the process and exempting certain property from levy in the tax sale context. And so they've provided the protections that may exist outside.
I think my point is rather that you're looking at a contract, a private contract, when you're looking at mortgage, and there are these built-in protections. You're looking at a constitutional right as with respect to private property as it relates to the government. It seems as though that if you're looking at protections, they should be at least similar.
Yes, and I think it's a pretty good sign that the tax sale procedures are constitutional in that they provide this, the tax sales that are conducted by governments look very much like the private mortgage foreclosure sales that banks and private lenders conduct.